This is your guide to book publishing. Everything you want to know but didn't know what to ask with your host, Dr. Judith Briles. On the show today, you'll find out where book publishing is going and how to take advantage of it. How to identify and avoid publishing predators. What opportunities are emerging as the book trade evolves in new forms. How to avoid losing money and much, much more. Join us now as a variety of publishing pros will deliver insights and strategies to take the author to the next level of publishing. It's your guide to book publishing. Everything you want to know but didn't know what to ask. Brought to you by AuthorU and the Book Shepherd. And now, here's your host, Dr. Judith Briles.
Well, it's finally, I think spring is here in Colorado. I have to tell all my listeners, we had a foot of snow dump on us over the weekend. And my guest is also in Colorado. I don't know how it was out in her neck of the woods of Boulder, but I can tell you in my neck of the woods, I had a foot come in. But it's melted because it's Colorado. It's here in an hour and gone shortly after. It's what happens here. But we don't want your writing to be that way. We want it to stick. We want it to stick and grow and domino. And there are things that happen that can get you into trouble. And it can get you into trouble by maybe you use material you shouldn't have used without permission. Maybe someone has taken your material without your permission. Maybe you just had some questions and you went down a wrong avenue. But here today, we're going to keep you on this straight and narrow legal path and protect you with some ideas that will really support you and your writing, because there's always questions, whether it's copyrights, whether it's trademarks, whether it is music lyrics, which authors seem to think that they can just use, and we're going to tell you, no, you just can't use them. It's a variety of things. But with me is Julie Bernard, and she has her firm located in Boulder, Colorado. She's a trusted legal advisor, and she exercises really special concentration in transforming intellectual properties into business assets, because look at your writing is an asset. During the time that she has worked with over the decades, hundreds of clients in preventing legal issues and structured numerous win-win outcomes when they arise. So she's got huge strength in patents, in trademarks and copyrights and all things legal. So we're talking intellectual property today. And with that, welcome to AuthorU, your guide to book publishing, Julie.
Thank you, Judith. It's great to be here.
So, I think it's always a good thing to just kind of throw out on the table, what are some of the biggest really mistakes, repeated mistakes that you see writers and authors kind of stumble upon?
The biggest mistakes I think everybody makes, whether they're writers or authors or inventors, is they don't think ahead. So common sense says if you don't put oil in your car, your engine is going to freeze up, right? So you have to think ahead and plan with a strategy. And so a lot of times everyone gets excited. Things are going well. They might have a contract. They might have completed something they've been working on for 10 years, and they forget to slow down, take a breath, and just think through, what am I going to do with this? What are the pitfalls? What are the positive things? And kind of make a checklist of what they need to go through. But I think everybody does it in lots of aspects of life. I think we get excited and we forget to slow down and use our common sense that we've been using for years.
So, I think that's a big one. When you mentioned contracts, that I had someone send over a publishing company. He wanted me to be supportive and refer people to them. And I said, send me your contract so I can look at it. And I said, you've got there's red flags in here. And he says, well, what do you mean? And I said, you've got a clause in here. I think it's nice that you've got a clause in here that the contract can be terminated. And in the traditional publishing always had a termination clause from, moral clauses in our contracts that we sign. Right. Yeah. And to CYA for them on their side. But that you've got a clause in here that says that the contract can be terminated if it's mutually agreeable. And I said to the person, I said, you know, when you want a divorce, a lot of times it's not mutually agreeable.
That's correct. That's right. And you know what? When I look at contracts, there's several, I would say there's three major things. One of them is the term and termination. You have to always be able to get out of it. You need to get a divorce sometimes, and you have to set that out. When you're still on good terms, if you can come to an agreement about how you're going to work the divorce, it goes much easier as opposed to when you've already gotten sideways with an author, a publisher, or anybody else.
Exactly, and I've been in that position before. I remember, I used to be represented by William Morris, not a small, agency. Mm-hmm. And they got me into a contract with a small publisher after I had been, I had been with all the big boys, and it was a very controversial book, and it was rejected, and I knew it was important, and it really turned to be a huge book for me. And that we went with a very small New York press. And I'm talking, it was hell. I mean, corrupt. And even, my agent at William Morris says, oh, these people are crooks. And I said, for God's sakes, get me out of this. You got me into it. Get me out of it. And here's what they said to me. If you decide to sue, we'll certainly testify on your behalf. That's what they said.
Well, here's the thing. As I said, I think in legal terms, whether it's a contract or a release or a permission, I think they're very intimidating, and people are afraid to admit that they don't understand it, or there's a word and there could be one word. The word indemnification sends people over the edge all the time. They don't know what it means. You know what? I say pick up the phone, call a lawyer. I'm sure almost anyone, especially me, I can guarantee, will talk to you for 5 or 10 minutes, maybe even 30 minutes, and explain what's going on. Can't give non-clients legal advice, but, these are things that we look at every day. We know what the words mean, and sometimes they just need to be set out in plain English. I am of the ilk that I can't explain it to a 12-year-old, then I'm using the wrong words.
Thank you very much. Thank you.
Well, that isn't how lawyers were brought up, I would like to say, or trained over the hundreds of years. In fact, lawyers used to get paid by the word. So the more words and the more flowery language you use, the more you got paid, 100 years ago. I think that's not how I do business. I don't think that helps my clients because it just creates more questions and confusion. So I have I'm going to make this so that anybody I know would understand it as much as I can. There are still words that, we just have to use.
And let me just say this. Any of you who are listening in and are contemplating going into a contract with a publishing company, and I don't care if it's New York, I don't care if it's one of these hybrids, and the hybrids kind of scare me to death with some of their stuff in it. That you are advised, the red flags are being held up here. Please buy an hour or two of an attorney's time who specializes in intellectual property and go through it and understand and explain to you in English, because a lot of these contracts are not in English. And that for the 12-year-old mentality, because I am, I'm on the soapbox, with Julie here. We're going to share the soapbox.
It isn't necessary, but that's a lot of contracts come from old templates.
Yes, they do.
And they have boilerplate language in them, which means it's standard language that everyone uses, and it hasn't been changed in 25 or 30 years. Exactly. It still makes sense if you're a lawyer, but to the average person, it may or may not make sense. And if you don't understand it, you could be committing to something that has very long-term consequences that you didn't mean to commit to. So for me, understanding is the number one thing.
Absolutely. So number one, understand what you're getting into. So going back to the contract that was put in front of me, there's actually two things I look for instantly, because I see contracts, a lot of these contracts, there's no money even going across. In fact, a lot of these contracts, the author is paying the publisher. And so, by the way, they're not publishing your book. You're paying them for a service to do whatever it is.
Correct.
And so I think different parameters better be in play. And one of those parameters is you need an exit clause that is very clear in common sense, in understandable English or whatever the language it is, so that you can pull the plug if need be. And so when I see a clause that says mutually agreeable, I want to throw up. So the other clause I look for, Julie, and maybe you can give us some recommendations on what kind of clauses we should be looking for termination, but the other clause I look for, and this has basically disappeared, is it used to be very standard in the old publishing clauses, and there was one called reversion of rights. And that's before, and actually those started disappearing when print on demand came into play. And the reversion of rights clause gave the author that the publisher sent you a nice little letter that said, we've really enjoyed working with you, but, all good things usually come to an end at some time, and that we're going to declare your book out of print. And we have X amount of copies in our inventory because they've printed them up. We've had X amount of copies, and we will, this is the other thing I want to see, that you as the author have the right to buy whatever remainder, and this is the right word, remainder copies are, at the publisher's cost. So you get them at a deep discount. And you kiss each other and you go buy. All right. So, and maybe, they're ready to buy your next book. All right. That's the way it was in the old days, by the way. All right. So you don't see reversions of rights because publishers today can hold your book, in hostage, basically in perpetuity, because they can go back to print. So here's what I would like to see crafted in, that a clause in there that, and this is another exit option for you, that let's say I'm going to just throw out the number 200 or 300. If your book sells less than 300 print copies in the year, you have the option to terminate the contract and take back the rights.
I think that's a great clause to put in there. I think that in addition to those reversion of rights,
Julie, let's hold on to your thoughts. I didn't see my cue, but we're going to take a quick break. This is AuthorU, your guide to book publishing. We're talking about protecting you and your book. We'll be right back.
This is your guide to book publishing. Everything you want to know but didn't know what to ask. With your host, Dr. Judith Briles. And we'll be right back with more great information right after these.
Is there a book in you or another? AuthorU will show you how to create, develop, and publish your book without being hoodwinked. If you already have a book out, you'll find a supportive and brainstorming community that's connected and creative no matter where you live. AuthorU brings in national experts for its book camps and annual author extravaganza held each May. It has regular meetings and delivers webinars for its members on timely topics. Through AuthorU's extensive network, members enjoy exclusive benefits, including significant discounts for a variety of services necessary to publishing. The Resource, its online book publishing news magazine, is content heavy and it's free. If you want to create a book that has pizzazz, punch, and panache, AuthorU is for you. If you're a hobbyist or a casual author, it's not. Join AuthorU today through its website at AuthorU.org. Follow AuthorU on Twitter at AuthorU and on Facebook at AuthorU, where timely author and publishing tips and articles are posted daily. AuthorU, where the author goes to become seriously successful.
First impressions are everything in the world of book publishing. Whether your book is an ebook, a print version, or both, your book cover needs to pop, sizzle, and sparkle to immediately capture the attention of your audience. And your book's interior needs to be just as dynamic and reflect the professionalism your readers demand. Nick Sellinger of NZ Graphics has won numerous national and international book awards for his cover designs and interior layouts. With over 20 years of experience in graphic design, he knows what it takes to create award-winning books and the many promotional pieces that authors need, such as posters, banners, postcards, one-sheets, business cards, logos, and more. Visit ncgraphics.com and see what authors and publishers have to say about their award-winning books and how NZ Graphics can make your book the success it was meant to be. That's nzgraphics.com.
Welcome back to your guide to book publishing. Everything you want to know but didn't know what to ask. If you want to write and publish a book, if you want to be successful as an author, your guide to book publishing, everything you want to know but didn't know what to ask, is for you. Stay tuned and you'll hear about statistics, scenarios, and strategies on what to do now to get you published. So let's get back to the show. And here again is your host, Dr. Judith Briles.
All right. So as we took that fast break here and there, we were talking about reversion of rights and making sure that you've got something in there and you need benchmarks to, you have to really kind of lay out a floor of what you can go in and claim. And I've always felt that because of the print-on-demand world, and contracts have changed quite a bit in publishing, is that you should put a number in, and 200 or 300. Then the reason why I use those numbers is because the typical self-published book sells 100 copies a year. That's a gulp to me. That's not very many copies. And if you've gotten in bed with a publishing predator and you're kind of stuck on how to get out of it, by putting in a number that is maybe 200-300 copies, that gives you much more of a door opener to bail out if you choose to. So that's my thought there. Now, Julie may have something else you might want to add on to it. With me is Julie Bernard. She's an intellectual property specialist and attorney. She's going to be speaking for AuthorU on Saturday. I think it's June 3rd, isn't it? Is it June 3rd, Julie?
Yes, it is.
It is. Okay, Saturday, June 3rd, in Denver, Colorado. If you can attend, you can actually register and get the video of it, as our AuthorU members can do that. So you can go on our website, AuthorU.org, just click on events. All the information is there. But knowing what your rights are, and knowing how to get out of something that maybe you've got into because you didn't understand what you were getting into, or some of the tips of what you should look for, yellow and red flags before you jump into anything, is just really crucial in the publishing area here. So Julie, do you have anything else you want to talk about on a reversion side that your experience can bring to the table?
Well, the reversion or a reservation of rights, I like to base them on metrics, and I'll tell you why. And when I say metrics, it's exactly what you're saying. 300 print per year or a sale, I like to base it on sales, and I'll tell you why, because then you have a black and white line. You either met the terms of the contract and we're going to continue forward, or the terms of the contract were not met and we're going to part ways under the termination clause. Mm-hmm. So under the termination clause, then all the rights should revert back to the author. If you reserve rights during the time, the term and period of the contract, you could reserve rights in a certain territory. So perhaps the publisher only wants to publish in print and they only want to sell them in the United States. You could reserve the rights to sell that book outside the United States. Or you could reserve all the rights for all the derivative works. Or you could reserve the rights for alternative medias. They only want to print books and you want to have ebooks. So there's lots of ways to parse up rights. But for me, when I'm looking at writing a contract, because I want clarity and consistency, everybody has to consistently interpret it the same way, and it needs to be clear enough that a 12-year-old can understand it. I do like to use black and white things like numbers. So your 300 print in a year makes me very happy.
Oh, good. And and Julie is actually right, because most of these publishing companies, they want e-rights. They want the ebook rights. and that you've got to, if you do a reversal, you've got to claim that everything comes back to you, and you must get them to take it off because they have control of your Amazon ebook sales or anywhere else it is. They've got control of that. So you've got to get them to take it down. So I'm going to tell all of you, I've pounded it on this before, that whenever reviews go up on your Amazon pages or Goodreads or anywhere, you should be copying those, putting them into your file, so you could have them to possibly resurrect. And the other thing is very critical for all of you to do is make sure as soon as you have an Amazon page that you create an Author Central account, because the people at Author Central can actually go in and do some copy pasting and put it onto a new page if you take control of your own books. But you've got to plan. This goes back to planning. I think Julie said planning, plan ahead, think ahead. This is the think ahead thing to do. All right, so I'm going to keep going. We'll get Julie back. It looks like she got disconnected, and we will give her a call back. So I'll continue on to this until we get reconnected here. So what's really important for you is to understand that planning and thinking ahead is essential to cover your tush, to protect your book, and to bring it back in play. And it's too often, as Julie said, and I mentioned just a second ago, and she's back with us again, this is all called thinking ahead, planning ahead. You can't freeze up here like not putting the oil in your car. This is just called author maintenance. So what do we need in my toolkit to protect me? So it started me on the contract thing, the mutually agreeable. We need to know what mutually agreeable means. You need to have measurable benchmark things that you can say, like if they said, for example, they were going to put $5,000 into marketing your book, and you can find nothing that shows that, they have misrepresented what they can do, and that means I can exit. At least I would interpret it as that. So
correct.
All right, so we can go on, but it's really important. So, Julie, let's talk about copyrights. One of the myths is that, well, I'll just mail myself a copy and I'm good. My understanding is as soon as you start writing, copyright comes into play, but there's other things that you should be doing. So, can you expand on this? Clarify?
Sure. So, that is a recent contemporary treaty called the Berne Convention. As soon as you fix something into a tangible medium, so if you print it, you write it, whatever it is, it's tangible and it's fixed, and it was an original creative effort, a copyright arises. And that began in 1989 in March. Prior to that, there were all sorts of different rules, and so when you're trying to figure out if there's a copyright on something or not and doing research, which everyone should do to make sure they're protecting themselves, there's several different things to look at. Mostly it's when it's created, when it was first published, and who created it. But for ease of this discussion, let's pretend we're talking from March 1st, 89 forward. It automatically arises. You don't have to mark it anymore. You don't need to put the the year, and the author's name. But I always suggest everyone do that. There's one situation where you really don't need to, which is when you're sending an unpublished manuscript to a publisher. They know the rules too. Mm-hmm. But otherwise, if you put it on there, it puts everyone on notice. They can't pretend that they didn't know it was copyrighted if they're not familiar with the rules. It gives you a defense in court. If you had to go after them, you can say it wasn't innocent. I put them on notice. How could they not understand it was copyrighted? So there's lots of reasons to put it on there, and they're all practical, right? It could deter someone because they think you understand the law. So I think that there are a number of treaties, and you can get copyright protection in a number of ways around the world, and the least amount of time is the author's life plus 50 under the Berne Convention Treaty. But
so it's no longer 70? I thought there was a 70-year rule.
No, the least amount worldwide, everyone who signed the convention, the least amount that they agreed to was author plus 50 years. In the United States, it's the author plus 70.
Got it. Okay. So it's you're talking about an estate. So if you've got a book that's really selling and might have lovely long legs to it, this needs to be included in your will.
Sure.
Yeah, this is part of the estate. Just talk to the heirs of Elvis.
You know what? Elvis and Michael Jackson, big ones that everyone watches, they also watch them for, defamation and privacy issues and publicity rights.
Aggressively.
So those things survive.
Yep. And actually, those estates have more value since their deaths.
I know.
The property than, under the Priscilla, for Elvis, Priscilla Presley was brilliant in what she did. All right. So it's understand now for copyright. Let's talk about the Library of Congress and actually officially filing. You can do it. It used to be we always mailed our books in. To the Library of Congress, and I kind of like doing that still, but
a lot of people are more comfortable with paper, and there's nothing wrong with that. You can also do it electronically. It costs more to send in paper because, of course, they have to have more manpower, and they're trying to deter people from doing that.
Yep.
But electronically or paper, they will both end up into a copyright registration.
All right, so let's talk about what happens if you get into a pissing contest. Someone infringes on your copyright. What's an author to do, Julie?
Well, first of all, before that happens, because I like preventative maintenance, within the first 3 months that you have published something, I would like you to file a copyright application, whether it's electronically or paper. And the reason for that is if you have to enforce your copyright, it gives you additional means to move forward. So if you have to sue someone and you have filed your copyright and it's registered, you can get what's called statutory damages. You can get your attorney's fees. Statutory damages means you don't have to prove damages. It's just statutory. It's by law. If they infringed, and the answer is they infringed, you automatically get $125,000 for each infringement.
Oh, okay. So let's come back with that, and we'll take a quick break, and we'll find out how we can get our money when someone's pirates.
This is your guide to book publishing. Everything you want to know but didn't know what to ask. With your host, Dr. Judith Briles. And we'll be right back with more great information right after these.
Want to publish like a pro today? Well, then take a look at Ingram Spark, the only publishing platform that offers print and ebook services through a single source. Upload, edit, and manage titles all in one place. Take more control of printing costs with print on demand, and reach even more readers through one of the world's most extensive distribution networks. Built by independent publishers for independent publishers, Ingram Spark has everything you need to maximize your book's potential: color printing, ebook distribution, print on demand, global reach, and more. Start publishing with Ingram Spark today and see just how far your titles will go tomorrow. That's ingramspark.com.
Many of us have dreamed of writing a book.
Some of us even have.
Then the hard work starts.
You'll need an editor.
Who will design the cover or typeset the pages?
Who will format the ebook?
If you're a business owner, consultant, or coach with a serious message and expertise to share, the team of experts at 1106 Design can guide you through the maze.
They've helped more than 1,000 authors create top-quality books and avoid the not-so-reputable self-publishing companies.
Learn more at 1106design.com.
Then call Michelle at 602-866-3226. 1106 Design.
When Ned Thompson and Harry Shore started Thompson Shore in 1972, they believed employees with great character would make up the best company. They were right. They hired people who were not only experts in bookmaking, but who were obsessed with quality and delivering exceptional customer service. Almost 40 years later, Thompson Shore remains a 100% employee-owned company. Ned and Harry knew that successful customer projects are a direct result of empowered employees. We specialize in all books for large and small publishers. Creating beautiful and well-made books, we're dedicated to pleasing our customers by making the experience a good one from start to finish. The personal touch we have with our customers allows us to be innovative in solving their most difficult challenges. Our platform also ensures that we can remain flexible to meet our customers' unique needs and expectations. Our marketing kit can create buzz for your title, enhancing the promotion of your book during infancy. When you need to test the market to gauge your future sales, we can provide digitally printed books that will transition seamlessly into a larger offset run. From ebook to hard copy to delivery, our skillful customer service teams are at the ready to answer your most pressing question. At Thompson Shore, we know that making the highest quality books requires more than just best technologies. It requires superior customer service, professionalism to the trade, and commitment to environmental and social values. With these standards of excellence in place, you can be sure that we will always help you put your best book forward.
Welcome back to your guide to book publishing. Everything you want to know but didn't know what to ask. Coming up, you'll hear more about statistics, scenarios, and strategies on what to do now to get you published. So let's get back to the show. And here again is your host, Dr. Judith Briles.
Okay, so as we went into the break, we were talking about infringements and doing it. And I did go through a situation, and the publisher was McGraw-Hill. And after I had had the rights reversed, everything back, I had the paper saying we've transferred everything back to you, I discovered a couple of years later that they had continued to sell the book in Europe and stuff, and it was translated into multiple languages. I never got a stinking penny for it. Now, clearly, my copyright, I had an infringement. That was a black and white thing. But I had gone through a situation where a partner had stolen some money from me, and just going through all that, I wasn't going to go through that emotional, and you need to understand before you don't sue on principle. You have to really think this thing through. And I knew what the energy drain is. I knew that it would cost, if I was going to go after a copyright infringement, which is what I was sitting on, that you're going to have to budget $100K. I wasn't willing to do that. And I would win, but I would lose in the end. My time, my energy, the emotional, and who knows what else. But I think you really have to think these things through. So what do you do? Julie, what do you do in these situations when you know you're right, but you can't afford to go after them or any of the other things that come with it?
Well, I think that in every case, whether you're right or wrong, because, of course, sometimes you come up with facts later in the case during discovery where you think, oh, maybe I wasn't right. But you have to do a cost-benefit analysis. Mm-hmm. And by that I mean there is not just a money cost, because lawyers are expensive, we all know that, but there is the emotional and professional cost to moving forward with cases. As you said, I always suggest people do not sue based on principle, because you may not have the same principles that are espoused in the law. You may not have the same principles that the person on the other side of the table has, and you may never agree in principle on something. So that's be based on fact and law. So that's the first evaluation. That's the first part of the cost-benefit analysis. The next one is, what's the real cost? The money cost and the emotional cost, because even if you have $1 million to spend on this case and you want to move forward, the emotional cost of suing somebody can sometimes outweigh everything else. It's hard to get deposed. It's hard to answer on a deadline, what did you do 3 years ago, and where's all the paperwork? So there's a lot of costs and a lot of benefits. Some of the benefits are if you win, and I will tell you that whether it's a bench trial, which means before the judge, or a jury trial, They're very unpredictable. You could believe that you have a slam dunk case and you could lose. So you have to be prepared for that big, long road because it could take, easily a year or two to get into court, and that year or two is very stressful. You have deadlines you must meet. You have bills you must pay. You have all sorts of things going on. And I will tell you, sometimes in the publishing area, people who pursue these, and they can get kind of nasty. It can affect your professional reputation, and you've affected that yourself, no one else. So I always say, let's do, and let's have, during litigation or during preparation for trial, let's have some no-go decision points. And what I mean by that is it worth it? Let's do the cost-benefit analysis again. Now we're 6 months down the road. Let's do the cost-benefit analysis again. Are you ready to go, or have we had enough? Sometimes settlements happen when both sides are just exhausted, and that's okay. So I prefer, rather than pursuing things after the fact in court, and you have to sometimes, you have to enforce your rights, I prefer to approach even someone who's a potential infringer and try and find a win-win outcome for both sides. If it wasn't on purpose, let's see if they want to take a license, if you want to give a license. If it was on purpose, let's send them a note that they have to stop, and let's figure out how they can do that, in the right timeline. But, excuse me, there's a lot of ways to find win-wins where people don't feel violated. And I will tell you, our justice system is set up to fix problems and not necessarily address them ahead. And so that's why I start with preventive maintenance, and then I try and find win-win. To me, the last resort is when you have fisticuffs in the court system.
Mm. Yeah, exactly. All right, so let's talk about, we talked about we have to really read these contracts and understand them and get them down to the 12-year-old level, right. Or have someone communicate with you what they mean in a 12-year-old level, which is really, but how about permissions? What do we need to get permissions for, Julie?
Everything.
So, got it.
Well, you should always take the position that someone else's work is copyrighted. It may or may not be. It might be in the public domain. They may have dedicated it to the public. They may have, there was a certain period of time where people had to renew copyrights, and they may not have filed their renewal, and it accidentally fell into the public domain. It might not even be copyrightable material. That kind of thing happens all the time. But when in doubt, assume that it's copyrighted, and then do some research, right? Mm-hmm. So I suggest before you approach someone to get a permission, do some research and make sure that it is copyrighted or that you need a permission. And if you're going to get a permission, and I'm talking about using someone else's copyrighted material right now, and I'll tell you, you know how real estate agents, I think their mantra is location, location, location. Mm-hmm. My mantra is get it in writing, get it in writing, get it in writing. Because even if you get run over by a truck and your estate has some issues, it's in writing and everyone knows what was agreed to. So when in doubt, get it in writing. Make sure that it has crystal clear boundaries. What are exactly the 12-year-old, what exactly are you agreeing to? Not necessarily even legal terms. Permissions can be 2 or 3 paragraphs. Very short. It could be 1 paragraph if it's written properly. But just needs to be crystal clear, and I say keep it simple and clean as much as possible.
All right. So if I let's just say I got a quote or I did an interview with somebody, and do I need to get now in writing that I have permission to use excerpts from that interview?
Well, you should. You should always get a permission if you can. There are certain cases where you don't need to. Again, you need to evaluate those things, right? So it's really a case-by-case. In general, my position is if you have any doubt, get a permission. It can't hurt. For example, if your children go to a summer camp, you know part of when you sign up for summer camp is permission to use their picture for advertising purposes, right? Mm-hmm. Mm-hmm. Now, do they really need that? Probably not, but there have been cases where parents have sued. They don't want their kids' pictures on the Internet, so people get permissions now And cases, when they go to court, are very unpredictable, whether you need permissions or whether you don't. And so, you know what, it's best to take the position that I'm just going to get a permission because it's a picture, it's a single quote. But there are certain things, if something is factual, you're just using the facts to report or to critique something, no, you don't need to worry about that. But in general, the first position I take is you probably need a permission, and then let's evaluate it from there.
All right, so it's very common. We have about 2 minutes before our final break, but it's very common that people might want to cite a few lines from somebody else's book. Mm-hmm. Do they need to get written permission for that?
Well, it depends on whether is it the heart of the book, is it the culmination of everything that was written in that book? Yes, that would be a big problem for the author. If it was just a couple of lines that they thought were relevant to what they're doing, likely not, because it's a couple of lines out of, let's pretend, 230 pages. So again, it goes to the actual situation and what are those lines that they're taking out. The heart of the book will send up a red flag to the author of the book or the publisher, whoever is in charge of that year. Or
I've seen people actually pull out pages from someone's work, and I'm saying you need to get permission from this. I mean, you just can't do this. And then the other thing is, and we're going to zoom right into our break now here, but the other thing is that if you are using musical lyrics, I mean, I had one book I made them take them all out of them because it was unbelievable. And then I had another book.
Even a single line. Yeah, even a single line from music.
Single line, you're going to get into deep doo-doo. Now, I had a book that the guy was going through. He's going through hell in a handbasket, and all he could do was remember, everything was supposed to change on Monday, and then the mamas and the papas, Monday. Remember that song? Yeah. And I said, Hans, for God's sakes, let me see if I can track down who owns the rights, and we did. And we told him what we wanted to do, and actually we had laid out the book already, using it, knowing that we would have to pull it. And I send them the chapter that it was in, saying this is how we want to use it. We want to print 2,000 copies, da-da-da-da-da-da. The cost to him to use those lyrics, which really did make the chapter, was $150.
Well, I was going to say it's pretty cheap. Sometimes it can be time-consuming, but in general, proper research, it's 1 or 2 months, and there are reasonable fees when you plan ahead and ask permission. If somebody has to enforce it and come after you, the fees get less reasonable.
Oh, and, yes.
Here
we go.
Don't offend people. It's the old saying, please and thank you. Just
ask. All right, we're going to be right back. It's AuthorU, your guide to book publishing. With me is Julie Bernard, intellectual property attorney, and we have one more segment, so stay tuned.
This is your guide to book publishing. Everything you want to know but didn't know what to ask. With your host, Dr. Judith Briles. And we'll be right back with more great information right after these.
The book shepherding concept is simple. The publishing world is changing, and so must you. You need an experienced shepherd and a guide to partner with you as you create, strategize, develop, publish, and achieve your publishing goals. You can't do it alone without paying the price. You can spend your money creating a book that turns out to be so-so, or you can create a book that looks and feels classy, builds your brand, and is a financial success, a bestseller. It's your choice. You choose. You need the book shepherd. Publishing is riddled with obstacles, sometimes nightmares for the author. You don't need problems. You want solutions. Dr. Judith Briles will shepherd you through the maze and the chaos. At times, she's had to step in and rescue a book that has been sabotaged by a publisher or by a publishing service provider or sometimes even the author themselves. Judith Briles is the book shepherd if you want to create a book with no regrets. Give her a call today. 303-885-2207. That's 303-885-2207. Or email her at judith@briles.com. By the way, Briles is spelled B-R-I-L-E-S. Follow Judith on Twitter at My Book Shepherd and on Facebook at The Book Shepherd.
One of the most important decisions you will ever make is your choice for printing your book. You are choosing a company which will be responsible for guiding you through the process and printing your book at a level of quality and detail that embraces your personal and creative needs. You want to choose a company that when your book finally arrives, you are delighted and ready to move on to the next level, and one that is customer focused. Choose King Printing Company and Addy Books to be that company that brings you to the next level. Go to kingprinting.com or call 978-458-2345 and ask for Tom Campbell.
At Total Printing Systems, customer service is our priority. We are located in Southern Illinois. Our employees have an average of 18 years experience and know that customer relationships are important to our continued success. We have been a short-run book printer for nearly 40 years and always stay at the forefront of technology. Our niche is from 1 to 5,000 copies. Today, we offer digital, black and white, and 4-color high-speed inkjet printing, a cost-effective way to introduce color into your short-run titles. We, of course, offer traditional offset printing as well. Bindery is done in-house, from adhesive case binding to PUR perfect binding to mechanical binding of all types, including side sewing. We provide warehousing, kitting, distribution, inventory management, a new print-on-demand facility, streaming browser-based ebooks, and bookstore. Call us at 1-800-465-5200 for a quote on your next book project. You can also visit our website at www.tps1.com.
Welcome back to your guide to book publishing. Everything you want to know but didn't know what to ask. If you want to write and publish a book, if you want to be successful as an author, your guide to book publishing, everything you want to know but didn't know what to ask, is for you. Stay tuned and you'll hear about statistics, scenarios, and strategies on what to do now to get you published. So let's get back to the show. And here again is your host, Dr. Judith Briles.
All right, our final segment with Julie Bernard, intellectual property attorney. She's based in Boulder, Colorado. And if you want to get a hold of her, you can email her at julie@bernardiplaw.com. So with that said, Julie, I wanted to jump into a couple of things because this really does tie in with all the preventive maintenance for authors. And one of my phrases I like to use, I know you've referred to common sense, I like to use the word good sense. Maybe common sense is too overused at times because I'm trying to figure out what's common sense anymore. But good sense, is it good sense? And one of the things that's challenging for a lot of authors, because a memoir is one of the big one, or they write fiction, but a lot of fiction is really guys, whether it's autobiographical or they're talking about deep, dark secrets. I mean, my goodness, if I could get in and do some of the dark shadows from, the Briles family when Franklin finally died here, one of the best things the man taught me, my father-in-law, was that how not to treat people. I mean, it's like everything is like, okay, you don't do this, Judith. You don't do this. His idea about people is they were like bricks. You just used them and built them up and, when you needed them. And when you're done, you just knock them over. And I'm just going, holy moly. But, that's not good sense. But it was, part of my lessons learned on how I would never treat people. Right. And so, how do you protect yourself from maybe any defamation and privacy-related issues? I mean, what paths should we go down?
Well, I think the thing to realize is that every character, whether you intend it or not, is probably based on something or someone in your life, right? Whether it's fiction or nonfiction. Yep. So
absolutely.
And whether somebody is family or not family may or may not make a difference because some people have close relationships, some people don't. So one of my litmus tests is if this would bother you, somebody in your family, if it would offend them, then you need to rethink it. And that's just one of your good sense things. There are 3 big risks, though, when you're writing about people in a memoir, and those are defamation, invasion of privacy, and misappropriation of their publicity rights. Now, if you're related to Elvis and you're writing about him, then and you're using his image for commercial purposes, right? His name or his image or his songs in the background of a commercial, that would be misappropriating publicity rights if you didn't have the right to use them. right? So
Mm-hmm.
If you have an endorsement contract from a big basketball player, if you have a permission to do that, that's a really great way to preventively just avoid misappropriating those publicity rights. The two big ones that are sticking points, I think, especially when writing a memoir, are defamation and invasion of privacy. So, defamation is just when you say something false, and it can be connected to an identifiable person. It gets published, and it causes them harm, right? It's a negative thing. A lot of people use the word slander and libel. Slander is when you say it, libel when you write it. But the bottom line is it's a reputation damage. And so to avoid that, you can potentially say that this is my opinion. However you phrase it, if it's your opinion, it's protected. Now, you have to be careful because you would have to have a reasonable opinion putting the facts together. Another way to avoid it is to change or mask the details so you can't connect the person with the false statement or the statement at all. I'm not saying that it's false, but that's when somebody gets offended, they're saying that it's false because it harmed them. So it may be true, and truth or a substantially truthful statement is a defense. So
does an author then possibly do a CYA? I mean, you see disclaimers often on copyright pages. Mm-hmm. That's where you put it in, and I didn't know that the magic phrase was "in my opinion," but boy, I've learned that one today.
I don't know but if you phrase things in an opinion way instead of stating them as fact, you're mm-hmm. allowing the reader then to form their own opinion, and you haven't given them a statement, right?
All right. So then I'm gonna jump on
disclaimers. Disclaimers are they look great, and I think that they put off a lot of people, but they don't hold a lot of legal weight.
They don't. Okay. So let me just. This is really off the wall thing, but this is off the wall. We have in our political environment, we have the Twitter in chief put out what would be called a libelous statement that Obama, what did he say? He wiretapped him in that tweet.
So what
that
happened
infamous
immediately?
tweet.
Do you remember? Everybody started investigating it to find out if it was truthful or not.
No, basically it's BS. Yes.
Well, whether it's BS or not, truth is 100% defense to slander and libel. So if you can prove it's true, you're off the hook. If it's not true, then you start falling down that slippery slope of how do you defend yourself.
So would this be something if Obama wanted to go after him, could file a libel suit?
Well, we live in a litigious society, and you can sue anybody you want. Mm-hmm. But that I will tell you that I didn't follow that as closely as clearly you did. But and I don't discuss politics too often. But again, the very first thing that I saw in the news was instantly there was an investigation into whether it was true or not, because that's what would turn a case, right?
Oh, sure.
Truth is the sole defense, and so that's what everybody started investigating whether it's true or not. Mm-hmm. So, but you know what? Even if it wasn't true, you can sue anybody you want. It doesn't mean you win. It doesn't mean you have a good case. Unfortunately, that's our society's stance right now on some things. But
so for a writer, what we want to say is that you don't want to say things that could get you into what Julie calls a slippery slope here. So so when you say it, it's slander. If you write it, which is what we're all doing here, then, you could be opening yourself up to a path you may not do. And then for memoirs, that you really have to be tuned into what's going on within your own family.
Mm-hmm. And I think that memoirs are masked a lot of times as fiction. And people change the name of the town, the name of the people, the relationship, the sex of the characters. And if you were in the family, you might be able to piece it together, but the average person might not be able to.
Well, not.
So
yes.
There are a lot of ways to mask these things.
So all of you need to be aware. You need to move around, because I've done over 10,000 one-on-one interviews for the books that I've written over the years, and I always had a policy of changing titles, locations, names. I mean, I even have them work with me. What name would you like to be called in the book? To do that. So they were in on it with it. But I will tell you, more times than not, people would call and say, "Oh, you used part of my story. I can see it here." And I said, "No, actually, I didn't use that part. I used something else." Because what I did, even after it was written up, I always sent out the pre and the post of the segment that I had an interview in. And if they were in Florida, they might end up in Chicago, but someone, and they, instead of being in the operating room manager, they might be head of HR, something like that. I would move things around to protect them. But people would still say, "Oh, I see you used my story." No, I always got them to sign off even after I did it so they could see how I was using it. Because, we've all had days where we wish to God what came out of our mouth didn't roll out. And we say things that we wish we hadn't said. So I always gave I didn't want my people to feel like they were victims, that they could do tweak and things, because we have those days. All right, so... I mean, Julie, before we leave, because we just have a minute here to go, what about when should we hire an attorney? When should we talk to an attorney?
You know what? I think there's easy and not easy. Easy is when you're in handcuffs, when you're in trouble, when you're in over your head, right? That's when everybody knows. But the best time in publishing to hire an attorney is ahead of time, because we can act as advisors or responders to problems, right? So we can do pre-publication legal reviews. We can help interpret what a contract says. We can help negotiate a contract. We can sometimes be the go-between so that you can keep a positive relationship with your publisher and you don't have to negotiate the contract at all, and they don't start thinking that you're greedy, that kind of thing. So,
which is a good idea.
It's a way to keep arm's length between you, or between the business part and the part that you really want to work on. So a lot of authors just don't want to deal with the business part. They really need a trusted advisor to help them and tell them what's in there and, what would be negotiable, what's not.
And so the attorney should be you want the attorney to be your advocate. And if someone's going to be the good cop, bad cop, you stay the good cop and let the attorney be the bad cop so you maintain the relationship with the person on the other side. So that's what I'd be looking for. And I'm going to have to do a wrap up with that. So Julie Bernard, I think everyone should come meet you if they are in Colorado and hear you on June 3rd. Go to AuthorU.org, click on events and sign up. If you live anywhere out of the area or just can't attend, you can still register and hear her wise words. And with that, thank you so much, Julie, for being with us.
Thank you for having me, Judith.
We're so glad. This is AuthorU, your guide to book publishing. I'll be with you next week. Keep on writing and enjoy the weather. Snow is gone.
Thank you for being a part of Your Guide to Book Publishing. Everything you want to know but didn't know what to ask. With your host, Dr. Judith Briles. Each week,